Today is Intellectual Property Crash Course, and we have David Hinton here. And David is the Acting Executive Director of Technology Ventures at the University of Arkansas. And so he basically accelerates the process of transferring innovative solutions outside of the walls of the university into the marketplace. He leads all aspects of the university's intellectual property commercialization pipeline. He works with faculty, he works with staff, he works with students to protect their intellectual property that can arise out of either research, projects, works, ideas, anything at the university. And so we are so excited to have him here, and I'm excited for you guys to hear from him today. And with that, David, I'm gonna pass it off to you. If you have questions during this, feel free to drop them in the chat, or David's fine if you wanna unmute and just ask in session, that's fine too. So David, passing it off.
Thanks, Stacy, for the great introduction. Really happy to be here. As Stacy mentioned, yeah, feel free to interrupt me at any time. It's a smaller group here, so we can have a conversation. If you guys have specific questions about specific things that you're working on, feel free to chime in. And if I don't know the answer, I can follow up and help you find somebody that does. As Stacy mentioned, I'm the acting executive director of Technology Ventures on campus. So we're the group that commercializes and manages the university's intellectual property portfolio. So intellectual property can take many different forms and be protected in different ways, and I'll go over that today. And so, our portfolio that we have at the university, includes a wide array of patents, issued patents and patent applications that protect the various inventions that our faculty and staff are developing. We also manage copyright of works of authorship, and we'll go through that. We also manage trademark, so not necessarily the Razorback logo or the university's logo itself, but if there's a trademark that is associated with a particular product or service within our pipeline, we can file trademark registrations. For example, if a particular faculty member maybe has sort of coined a phrase or a term in the art, they've come up with a particular name for something that they're working on, and maybe they've published about it, we can work with them to trademark that term. And then we also work a little bit with trade secret information. So not a lot, since the university is generally in the business of public dissemination of information and knowledge, but sometimes this takes the this comes up with sort of unpublished data and things like that, and there may be economic reasons that we may not want to sort of publish that, but maybe transfer it to a company where they can leverage that asset. And so, Technology Ventures at the university, really sits sort of at the center of science, business, and law. And so it's kind of a really unique opportunity to get all of these people in the same room talking to each other, since they really oftentimes speak a different language. And so my background is in science, and my PhD is in neuroscience, and then also have a background in business. Made my own run at a few startup companies, and also have an MBA. And then I'm also the interim director of the Arkansas Research and Technology Park, which is a campus down south of the university on the intersection of South School and Cato Springs. And we have rentable office space that's available for companies. And so it's nice to work with intellectual property, licensing that to companies, and then also being involved in um, leasing them office space so that they can set up shop near the university and continue to collaborate with our faculty members. My contact information is down here. Feel free to reach out at any time. If you have general questions, if have something that you're interested in, maybe you found a patent application and you're curious about some of the information in there. I love helping out. So feel free to reach out at any point. So today we're going to talk about intellectual property, and I sort of briefly mentioned the different types of intellectual property and the different ways that the intellectual property can be protected. And throughout the talk, I'll mainly focus on patent applications and inventions that can be protected via a patent. And so I'll go in depth there throughout the presentation. But at the beginning here, I'll touch on some of the others as well. Actually, let me start with patents. So a patent, protects an invention. So you have to be able to describe what that invention is. You actually have to teach people how to make that particular thing that you're developing. You can protect a device. You can protect a method of manufacturing. You can protect a new plant variant that you have developed. So there's many things that can be patentable. And again, we'll go more in depth into that. But one important concept about a patent is that it's actually a defensive tool. And so a lot of people don't necessarily appreciate that it's purely a defensive tool. So just because you have a patent, and let's say that patent application has gone on to issue in the United States, just because you have an issued patent, you actually don't have the right to make, use, or sell. So a patent doesn't actually give you the right to make, use, or sell anything. What a patent does is it gives you the right to prevent other people from making, using, and selling. So it's purely a defensive tool. It's a fence that you can put up around your particular area. A fence around your invention. Similar to a fence that you put up around your, actual property, right? Your real estate. You put up a fence to prevent your neighbors from coming onto your property. You file a patent application to prevent your competitors from being able to make, use, and sell what's described in the patent application. So sometimes it's a little bit confusing. You can say, well, okay, so I've filed this patent application, it's gone on and issued. Why can't I, why doesn't this give me the ability to make, use, or sell something? And the example that I like to give is, let's say that you're working at the university, maybe you're studying diabetes, and you have identified a particular molecule that you think, small molecule that you think would work really well to, let's say, cure diabetes. And fortunately, it's not a new drug, and it's not a new pharmaceutical compound. Actually, Pfizer has developed this compound, but they don't know anything about diabetes. There's no information that I can find online or anything that anybody has tried this drug in diabetes. They're using it as a cancer therapeutic. And so, I think that, based on all of this information I know, based on my expertise, based on the research that I've already done, I know that this compound can actually be used to treat diabetes. So I can actually file a patent application using Pfizer's drug to treat diabetes. So this is a method of treatment. And I could have that, patent application I go through, I prosecute it, it goes on and issues in the United States. And now, I want to go out and I want to use that compound to treat diabetes. I want to start selling that drug. Well, I couldn't actually do that unless I go back to Pfizer and say, hey, I need to use the compound that you guys have invented and developed and patented. I'm not using it in cancer. That's what you guys are doing. I want to use it in diabetes. So because Pfizer has a patent on the compound itself, the medicine, the drug, the molecule itself, they can prevent me from making, using, and selling that drug, regardless of what I'm making, using, and selling it for. But I, based on my issued patent, I can prevent them from making, using, and selling it in for diabetes treatment. So, so that's where I would have to get a license from Pfizer to use their drug to treat diabetes, but they would have to get a license from me in order to use their drug to treat diabetes. So, that's where it's purely a defensive tool, and it doesn't actually give you the right to make, use, or sell anything. So that's an important point to realize about a patent application or an issued patent. The other important thing about a patent is that it actually lasts for 20 years. So the federal government is essentially giving inventors really a monopoly on this particular invention. So they are allowing the inventors to prevent everybody else, all of their competitors, from making, using, and selling that invention or product for 20 years. Why do you guys think the federal government, with all the antitrust laws and things like that, we've learned a lot about that through Facebook and and these various companies trying to explain that they're not actually a monopoly, right? So the federal government has antitrust laws that say you can't have a monopoly in a particular space, but yet they're allowing inventors to have exclusivity for 20 years for a particular invention. Why do you guys think that the federal government is granting us 20 years of exclusivity?
Anyone, you could write it in the chat too.
No one?
I'll take a shot here, David.
Yeah, thank you, Justin.
I'm guessing 20 years exclusivity. I mean, for a lot of companies, is the R&D expenses that come up front. So to recoup those costs, the heavy investment on those things up front.
Yeah, no, that's definitely an interesting point. A lot of products, I gave the pharmaceutical example. If you look at the sort of national average, it takes about 16 years or so from conception of a new compound until that compound is FDA approved. So, maybe you could make the argument that it wouldn't be worth it for companies to invest in the R&D of a new drug if it's going to take them 16 years to get it to market. Let's say they file today, they're only going to have 4 years of patent runway left to be able to prevent their competitors from making, using, and selling. And now generic drug manufacturers can swoop in and start, profiting off of all of the work that this company did to take this compound through regulatory approval. That could be could be part of it. Certainly, you know, I think that touches on this idea that the federal government, you know, really wants to promote innovation. So, you know, in a way, you know, allowing that amount of time of exclusivity could help to promote innovation, to encourage companies to invest in that R&D. Yeah, I think so. I think the other reason is also related to promoting innovation in that, you know, a patent application eventually goes on to publish. And so you can search, you can go to uspto.gov, or perhaps easier, go to patents.google.com, a much more user-friendly version. Although if you log into the USPTO's website, you can get a little bit more information about a particular patent application. But yeah, you know, you can go and you can search for these published patent applications. And just because a patent application has been published, it doesn't actually mean that it has been issued yet. And so if you remember, in a patent application, you actually have to teach people how to make or use your invention. You have to document it. And if you don't provide enough information to teach people enough, then your patent application actually isn't going to go on and issue. And so it's, so, you know, people may be hesitant, investors may, or inventors may be hesitant to, you know, write down and explain their invention because they don't want their competitors to learn how to do that thing, right? And so maybe the natural sort of tendency would be to keep that information as a trade secret. But, you know, if we keep everything a trade secret, now there's not this public record of all of these great inventions that have been developed. And, you know, throughout the course of history, there are stories where, for example, concrete was invented way back when, and, you know, somebody figured it out and they're like, well, this is just the greatest thing ever. I'm going to keep this a secret within my family, and we're going to build the king's temples out of this. And, you know, this is just the best thing ever. And then the plague came and everybody died. And then we forgot how to make concrete. And then it was invented 100 years later. And then the war came and everybody died and we forgot how to do it again. And so, you know, the federal government really wants to encourage this, you know, public record of inventions, so we don't forget what we've done, but also so that others can go and see what other people have invented, so that we can invent on top of it and continue to improve and not have to continuously reinvent things, so that we can have a more efficient process. And in exchange for asking inventors to document and write down and publicly disclose, right? So, you know, publicly document what their invention is and teach everybody how to do it. The federal government says, you know, in exchange for that, we're going to give you 20 years to essentially be able to commercialize this thing exclusively. So, yeah, absolutely, Justin. Yeah, to promote innovation would be probably the short answer. Let's see. I'll go more into detail about patents here in a little bit, but let's switch gears here to the next form of intellectual property, which is copyright. And copyright protects works of art, or works of authorship, I should say, including works of art, including, you know, books, poems, you know, songs, computer code. Copyright is unique in that the ownership of copyright is automatically awarded to the authors of that copyright. So you actually don't necessarily have to go out and register your copyright in order to claim ownership. The fact that you're the author of it already establishes you as the owner of that copyright. Now, registering it does provide some additional legal protection, and it makes it easier to recoup damages if there is an infringement case. But if you're the author, you can just put the circle C and your last name and the year next to the work of authorship that you have created to signal that you are the owner of that copyright without going through the process of actually registering it. Copyright lasts for the life of the author plus 70 years. So it lasts for a really long time. The song Happy Birthday, fortunately, just came off copyright. So we can all feel comfortable now singing Happy Birthday, and we don't have to be worried about infringing on anybody's copyright. Although I'll miss the songs that all of the restaurants used to make up to replace Happy Birthday. Also, I think it's Steamboat Willie and Mickey Mouse. I think that is coming off copyright here. I think it might be next year. So very soon, Mickey Mouse may be in the public domain if Disney is not able to continue to lobby the federal government to extend the protection of copyright as they have done in the past. So it has continually sort of got longer and longer, the protection of copyright. There are a few interesting recent examples that I want to share related to copyright infringement. The US Postal Service recently created a stamp with a picture of the Statue of Liberty on the stamp. Unfortunately, they used the picture of the Statue of Liberty that is depicted on the right instead of a picture of the Statue of Liberty that's depicted on the left, which is the Statue of Liberty in New York. The Statue of Liberty on the right is a sort of replica or satiristic version of the Statue of Liberty that's displayed in Las Vegas. And the author, the artist that created the statue that's in Las Vegas, caught wind that the US Postal Service was using his sculpture on their stamp, and they were selling and monetizing a replica, a picture of his sculpture. And he sued them and won $2 million from our US Postal Service for using his sculpture. So, it's really important to make sure if you're using an image of something to make sure that you know what that image is, or that who the author of that image is, or who has created what is depicted in that image, so that you can make sure to get the proper permissions to be able to use that particular work of art, especially if you're going to go out and monetize and make money off of it. So, there are various Creative Commons licenses and things like that are available to be able to use various images. So you can do Google searches and you can find sort of royalty-free images, or you can find images that have agreed to follow the Creative Commons guidelines, where you can just provide a a citation and use it sort of free of charge. But it's something to be very aware of, as our U.S. Postal Service made the mistake of using somebody else's work.
Hey, David, can I interrupt
Yeah.
here? I've seen a couple of questions come in to me that were related to company logos, and wondering if that's important to get copyrighted. So throwing it out.
Yeah. So a logo is a interesting thing, and you know, a lot of things you can actually get multiple forms of protection on. So you know, for example, a company logo is one of those things where you could copyright the actual you know, logo itself, but then you could also register it as a trademark that is associated with your, you know, product or service that your company is delivering. So yeah, I mean, yeah, absolutely. A copyright on a company logo is very appropriate, and perhaps you know, a really smart move, because as I'll mention in trademark law, in order to infringe on a trademark, it actually has to be confusing in the eyes of the consumer. So, for example, you know, if you know, if and well, actually, here's a really good example of that. So, Rob Gronkowski, you know, now of the Tampa Bay Buccaneers football player, started a company called Gronk's Nation, and he filed a trademark registration of the image on the left, which is a silhouette of him spiking a football. And you know, he with trademark, you actually have to select individual product classifications to use your trademark on, because again, a trademark has to be specifically associated with a product, and then a service mark is specifically associated with a service. So like a plumbing service, for example, versus an actual tangible product that you're selling. So there has to be that association in the eyes of the consumer between your mark, your logo, or your phrase, or your words, your name, and that specific product. So there has to be that association, and you actually have to use it in interstate commerce in order to register that trademark. And again, in an infringement suit or in a registration of that trademark, if something is confusing in the eyes of the consumer, so the consumer sees a particular logo and they say, you know, hey, that reminds me of this other thing that's not your service, then that's confusing in the eyes of the consumer. So Rob Gronkowski went out and tried to register this trademark on athletic apparel for his Gronk's Nation company that he was starting an athletic apparel line. He was also starting a party bus line of products. And as part of that trademark registration, you have to submit it. And then there's actually a review process where other companies can submit claims that say, you know, hey, wait a second, that looks pretty similar to my logo. I think that this is going to create confusion in the eyes of the consumer if you allow this thing to be registered. And so that's another important aspect of trademark, is that you have to continuously be out defending your trademark, because if you don't, you can run the risk of losing that trademark or losing that association, or that trademark becoming sort of, you know, general kind of knowledge, or you know, kind of that mark becomes generalized, where people start using the mark to talk about not just your product, but a general line of products. This is why Google wants people, instead of saying, you know, Google it, They want people to say search using Google. So they want their, trademark to be associated with a particular, search engine, not with this sort of general process of searching on the internet. And so if you don't go out and continuously protect your trademark, you can run the risk of that mark being generalized and basically being adopted by the general public. And now it's no longer associated with your product or service. You sort of lose that association, right? And so Nike and the Air Jordan brand of Nike saw that Rob Gronkowski with Groks Nation was trying to register this silhouette logo. And they said, whoa, 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 that looks really similar to our logo, especially because he's trying to use it on the same products that we're using our logo on. So remember, you have to specifically register a trademark on a particular line of products. So, Nike has a registered trademark of the Michael Jordan dunking a basketball on athletic apparel. And so the trademark registration was actually denied for athletic apparel. So Nike sort of won that appeal. But fortunately, Rob Gronkowski and Groks Nation was still allowed to use the logo on his line of party buses, since Nike doesn't have that product or service, and it wasn't confusing in the eyes of the consumer. Here's another example, and I think this one is still pending. But there's an app. It's a recipe plan app in the App Store. You can make grocery lists and meal organizers, and it's called Prepare. And they are using this. They're proposing to use this pear logo for their app, and Apple said, whoa, 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 that looks really similar to our Apple logo. I think this is going to cause confusion. The leaf is at a particular angle, and right? So but they have the responsibility at, you can kind of laugh at that and be like, that doesn't look, come on, Apple, you're trying to sort of strong arm this maybe startup company from using this logo that they have maybe already tried to establish a brand with. But Apple actually has the responsibility to do that, to go out and continuously protect its brand and its trademark. Otherwise, as more and more things get more similar and closer and closer and closer, then that Apple logo can run the risk of being generalized. Like some of these brands, for example. So you can get a trademark, as I mentioned, on the on a word or phrase itself. So a word mark, or you can get you can get a logo, a trademark on the actual logo itself. And so these are some examples of brands or products where the actual word mark, so not necessarily the logo, but the word rollerblade, for example, has now become synonymous with inline skating. And so they lost the trademark on the phrase, the word rollerblade, although they still have the trademark on their logo. Same with popsicle. Right? So nobody says frozen treat on a stick. Everybody calls everything a popsicle, regardless of whether or not it's actually a popsicle or not. Same with Kleenex. Nobody really, you hear more, facial tissue or something like that, or tissue, but you hear people say, Kleenex all the time, but that's actually a particular brand of tissue. And the one that I learned about was actually dumpster. I didn't realize that was a trademark from the Dempster company that I guess created the dumpster, but now the dumpster is a very common language. So, anyways, as a brand, you have the responsibility to continuously be out there defending your trademark. Otherwise, you have the chance of losing that trademark. The other interesting thing about, so I hope that answered the question about whether or not a company should sort of copyright maybe their logo. So the advantage of doing that is that then you have the ability, to really prevent people from reproducing that logo itself, regardless of the application of that logo, right? With copyright, but with trademark, you can, you're only concerned there with confusion in the eyes of the consumer. So that mark has to be, intimately associated with your product or service that you're delivering. So a logo can technically be reused, as long as it's not causing confusion in the eyes of the consumer. And so that's where copyright protection comes in to then, if you have a unique logo that you're using, if you copyright it, then you can prevent the reproduction of that for other companies, potentially using that, nobody else would be able to trademark that in a different line of products, than what you've registered that trademark for. Trademark is another example of something where you actually don't have to register it. So a non-registered trademark, the logo there is the TM. So, on some logos and phrases, you'll see the use of TM. The registered trademark is the circle and the little R inside the circle. So now every logo that you'll see, you'll think in your mind, is that a registered trademark or is that not a registered? Is it a TM or is it the circle R? So, as the author or the creator of a trademark, again, the ownership is automatically awarded to the creator. So, here again, registration allows it to be a little bit easier to recoup damages. It's also a federal registration, so it allows you to use and protect that mark, nationwide, versus sort of the protections that you get without registering it are more sort of local, and you get some state benefits. And so, if you're a small business and operating in a single market, you may not be concerned necessarily about registering that mark, nationally. It may be more important to you to have that more local and regional protection. But if you need that national protection, that's where also registering the trademark comes in. Also with trademark, you can trademark sounds. So that's pretty interesting. So for example, Netflix, the bum bum, and I'll probably get sued for making that sound. But that bum bum sound, when you fire up Netflix, they actually have a trademark on that sound. So every time you hear that, you think about Netflix, right? The old example of that was the Roaring Lion from MGM Studios. So they have a trademark on that lion's roar before the movies started. So Hulu's the same. They have a trademark on their little chimes that play when you fire up their service. So you can also register a trademark on a smell. So that's pretty interesting. You can have a smell mark. It's not something that seems to be widely used. And every time I talk to people about it, I ask people why. I was actually talking with the head of the U.S. Patent and Trademark Office and asked him sort of, why do you think people don't really use smell marks that much? And I haven't really got a good answer yet. But so my background was in neuroscience, and there are some super strong associations between smells and memories, right? And so it seems like you could potentially create a very strong, connection with your brand through a specific smell.
Yeah. Justin just mentioned Abercrombie and Fitch.
Mm, yeah, no, that's a really good point. Yeah, every time you walked into their stores, you smelled the cologne. And so that's another interesting example where you could potentially file a patent application on the specific chemical formulation of that combination of molecules that produces that smell. You could potentially do that. But again, that fragrance manufacturers may not want to do that, because after 20 years, that information is in the public domain, and now you could have other generic companies produce or replicate your exact smell. And so most fragrant manufacturers will keep that particular recipe as a trade secret, right? So they can continue to make it without actually disclosing exactly what makes up that particular smell. But then you could also combine that potentially with a trademark registration on that smell. But again, I think the hard part is that with trademark, you have to have that that association between the product and the fragrance, which I think definitely Abercrombie has. Play-Doh has a smell mark on Play-Doh. I think it was Verizon Wireless has a smell mark on some kind of like musty, flowery smell or something of their stores, which I don't think I've ever really smelled anytime I've walked into there's not a strong association in my mind with that particular product. So I don't know. It's just an interesting thing to be aware of, that you can trademark smells. So the final form of intellectual property, there are others, but these are the sort of the four common types. There's also a trade dress, which is an interesting one, which is mainly used in like the packaging industry. So with trademark, it's only a two-dimensional image, and there's no color associated with it. But with trade dress, you can protect three-dimensional objects. Like you could think about like the Coke bottle, for example. You can protect that sort of three-dimensional shape of it. So trade dress is another interesting one that you can explore on your own. But trade secret is the final one that I want to touch on. And as I mentioned, at the university, a lot of times that takes the form of unpublished data and that type of thing. The famous example is the recipe for Coca-Cola. They could have written down that recipe and potentially protected that via a patent application. And they could prevent their competitors from recreating or making, using, and selling that specific recipe. But again, after 20 years, those protections would have went away, and there could have, anybody then could have made Coca-Cola. And so they made the decision that, we're going to keep this as a trade secret, and not share that information with anybody. Trade secret is nice because theoretically it can last forever. I should add that trademark lasts for 10 years, but then you can renew it. I forgot to mention that. So provided you're still using it in commerce, you can renew it every 10 years. So with trademark, or with trade secret, that protection theoretically can last forever, right? The challenge is that you need to keep it a secret. So, once the cat's out of the bag, once that secret is out, you can't get it back, right? Now, there are protections available if something is disclosed sort of maliciously, right? So, if you have a disgruntled employee that discloses your trade secret information, you can recoup damages from that malicious disclosure. But again, the secret's out now, right? You can't put it back in. So, that's what's challenging about trade secret. It has the benefit of being able to last forever, but if it gets out, you're kind of out of luck there. And so you really need to have policies and procedures in place, to only disclose the trade secret information to those that need to know it, or only disclose parts of it to some people and other parts to other people, and so only people only know half of the information. Other famous examples is KFC's herbs and spices. It's been interesting because I was listening to I think it was like a documentary or a podcast or something about the herbs and spices, and that people have been trying to reproduce that recipe for a long time. They've stuck it in a mass spectrometer to try to get a chemical profile of it, and nobody's really been able to get it right. But the other thing with it is that it continues to evolve over time, right? So that's often the case with trade secret, is that things continue to evolve. Even Google's algorithm, which is something that is a trade secret to them, I think is updated like 2 or 3 times per day, or something like that. So that's another way that you can keep your trade secret information secure, is by continuously evolving and updating and changing. I think that's let's see, we only have about 10 minutes left here. I can open it up for questions here if there are other specific questions. I can also dive a little bit more into patents to let you guys know kind of what sort of specifically is patentable. But maybe I'll pause here and see if anybody has any specific questions. And if not, then we can maybe proceed for a few more minutes.
I'll ask a question, David, if nobody wants to jump in here. So about patents, I like to think about this. I'm sure you've heard of the one about Alexander Graham Bell. So when he filed his patent, there were 2 other, I think 2, maybe 3 other inventors at the same time, or within the same time frame, that had also came up with the concept of the telephone, right? And so, but he was awarded the patent, and he's famous for it. You don't remember the names of, I think, Anthony Meucci and Alicia Gray, but it promotes innovation. But in that sense, this person was awarded a patent for a long period of time. In that sense, could it have stagnated into innovation? Possibly, because just one person was the one that could take that forward. So how in those cases, when something's being developed by lots of other people, do you look at that?
Yeah, no, and that's a really good point. And one of the things that I didn't mention, so the law has recently changed in terms of who is awarded a patent if there are multiple people who have independently developed the same thing. And so the law used to be that it was the first inventor that invented something that would be ultimately awarded the patent, even if they filed the application after somebody else. So if you could go back into your laboratory notebook or journal or information and provide evidence that you were actually the first inventor to conceive or reduce this invention to practice, then you could be awarded the patent instead of these other people, even though they filed the original patent application before you did. The law now is that it's a kind of a subtle change, but the law now is that in order to be awarded the patent, you have to be the first inventor to file a patent application. So you still have to prove that you are an inventor of the technology. It's not like, if you disclose somebody to something, if you disclose something to somebody, let's just say maybe in the absence of a non-disclosure agreement, now they go out and they quickly file a patent application before you do. But they really can't clearly show or provide any evidence that they were actually an inventor of that technology. They just actually were able to file it before you. Then you, if you have the evidence that shows that you developed it or conceived it, reduced it to practice, then you would ultimately be awarded the patent. So, but it's the first inventor to file. So if there are multiple groups that all have evidence that demonstrate that they are the actual inventors, the patent would be awarded to the first group of inventors that filed the application. Versus before, if you were able to prove, well, no, I actually came up with it 5 years before they did, even though they were inventors, I came up with it before them. Then I would be awarded. It's no longer that. It's the first inventor to file a patent application. So in that sense, there is a race a little bit, right, to the patent office, and it creates sometimes some anxiety with inventors because inventors are notorious for assuming that anybody can come up with this idea, right? I mean, it was so easy for me to come up with this. Everybody's breathing down my neck, coming up with this invention. And so there really is a little bit of a race to the patent office. So you kind of have to play a little game related to especially like in the pharmaceutical industry, for example, where it takes so long for something to get to market, right? If I'm a pharmaceutical company, I'm going to want to delay my patent filing as long as possible so that I have as much time, as much patent life at the end of my patent application as possible. But if somebody else files before me, there's a lot of risk there. So I don't know if that answered your question or not, but it's an important distinction of the new law that it's the first inventor to file now.
Awesome. Any other questions? Ontario, I think we answered your question regarding the logo and trademarks. Anything else out there? Okay.
I can share just a couple more quick points about patents. So I kind of touched on the fact that you can patent, a device, which is kind of depicted over here, versus a design. So you can actually get a patent on a particular design, where a patent on a device, a so-called utility patent, has to actually have a function or a use. A design patent, by definition, it is not useful. It's purely an aesthetic feature of something. So furniture manufacturers a lot of times use design patents. Apple has a very valuable design patent on this portable display device. And if you look here, it's the claim is the ornamental design for a portable display as shown and described. And here you can see that the shade lines in the figures show contour and not surface ornamentation. The broken lines in the figures show portions of the portable display device which form no part of the claimed device. So the only important feature, so none of these dashed lines are actually important. The only important feature, and I don't know if you can see my cursor, but it's the solid line that goes around the edge of the device. It's essentially a rounded corner rectangle is what they have a design patent on. And so this was very valuable because actually Samsung's smartphones also have, their portable display devices also have rounded corners. Apple sued Samsung for $1 billion because Samsung's phones have rounded corners, and they won. The judge awarded Apple all of the profits from Samsung's portable display devices, smartphones with rounded corners. But Samsung appealed. They said, surely the only reason people are buying this isn't because of the rounded corners. They ended up settling for $500 million, literally because of rounded corners on a cell phone. So design patents can be valuable. We at the university, don't utilize them very much, just because most of the inventions that are disclosed to us are more in sort of the utility space. But I just want to mention that you can also patent a design element.
I had a question.
Yeah, please.
Could a design element be considered as like creating a new hairstyle?
I don't know.
I mean, because like, through the 70s and the 80s, like a lot of different hairstyles was getting created, and I'm sure like it had to be like maybe a process of putting a patent on the creation of that, so nobody else could do it.
Maybe if it was like a wig, for example, where you have a product that you're actually selling, and you can maybe I don't know. I'd have to think about that a little bit. I can follow up with you, Ontario. It's a good question, though.
Great question, Ontario. I love that. I think it's clever, and I've never thought about it. So if you want to stay on and ask any other questions, we'll be here for a few minutes. It's 5:30 though, so we do want to end on time. If you need to go, please feel free to head on out. But thank you, David, for your time and your expertise here, for sharing with us on IP. And if you have questions, be sure and connect with David. We provided his contact information in the chat. You can reach out to me, you can reach out to him, anyone here. So thank you, David. And again, if you have questions, feel free to hang out and chat with us.